Welcome back to the deep dive. You know, we spend a massive amount of time in the legal world obsessing over the honeymoon phase of a contract.
Oh, yeah.
The offer, the acceptance, the handshake, the meeting of the minds. It's all very romantic.
Yeah.
But today we are fast forwarding to the reality of the marriage.
Right.
We are looking at the machineries of performance.
Okay.
And specifically, we are staring down one of the most dangerous, high-stakes two-letter words in the English language.
Yep.
If.
If. It is a tiny word, but in the legal world, it is a toggle switch that controls millions of dollars.
Exactly. This is the territory of contract conditions.
Yeah.
This is the I will pay you a bonus if you hit your sales target, or I will buy your house if the roof passes inspection.
Mm-hmm.
It sounds simple, but what happens when that if never happens? Does the whole deal just implode? That is the central legal problem we are tackling.
It is the operating system of the contract.
Yeah.
You can have a perfectly valid agreement, signed, sealed, consideration on both sides, but if a specific condition doesn't trigger, the duty to perform just sits there inert.
Or a party tries to use it to escape.
Or conversely, if a condition fails, a party might try to use that failure to escape a deal they no longer want. Yeah.
Our mission today is to rigorously dissect this machinery. We are not just reciting definitions here. We are going to look at how conditions are classified, how the law actually creates them out of thin air, even when the parties forget to write them down, and, crucially, how parties try to dynamite their way out of them using excuses.
Dynamite is a dramatic way to put it, but it's pretty accurate. To guide us through this, we have a specific roadmap.
Okay.
First, we need to handle classification distinguishing between conditions precedent, subsequent, and concurrent. Second, we have to look at creation.
Right.
Specifically, the massive historical shift from independent promises to dependent promises, which gives us the doctrine of constructive conditions.
Then
Finally, we get to the escape hatches. We will examine how conditions fail or are, excused through waiver, hindrance, and the equitable doctrine against forfeiture.
So these are the tools lawyers use.
These are the tools lawyers use when the strict letter of the contract seems to create a result that is just, well, it's just too harsh.
Okay, let's unpack this. Let's start with the basics of timing. To the uninitiated, a condition is just a condition. But you and I know the law loves to split hairs between condition precedent and condition subsequent. Is there actually a meaningful difference there, or is this just Latin for the sake of it?
It feels academic, but it really drives the logic of a lawsuit. It all comes down to when the duty matures. The general rule is that a condition precedent is an event that must occur before a duty to perform a promise arises.
So using the real estate example, I will buy your house if I can get a loan approved by Friday.
Precisely. Obtaining the loan is the condition precedent. Until that loan is approved, your duty to buy the house doesn't exist. It hasn't triggered.
Okay.
If Friday comes and the bank says, no, you aren't in breach of contract, you just don't have to perform. The deal, it just evaporates.
Okay, so that's the if. What about the condition subsequent? That always felt backward to me.
That is because it is backward. A condition subsequent is an event that terminates a duty that has already matured. The duty is happening right now, it is live, but if this specific event occurs later, the duty is extinguished.
Like, I will pay you a monthly allowance until you remarry.
Exactly. The duty to pay is active right now, but the event of remarriage cuts it off. Now, practically speaking, the distinction, it usually doesn't matter to the client. The money starts or stops either way.
But in court.
But procedurally, it affects the burden of proof in court. For a condition precedent, the plaintiff usually has to prove the event happened to win. For a condition subsequent, the defendant has to prove the event happened to get out of the duty.
It's just the chessboard. That makes sense. Now, here is where it gets really interesting. Those are express conditions, things we write down.
Right.
But what happens when the contract is silent on timing? If I agree to sell you my car for $5,000, but we don't say who goes first, do I hand over the keys and hope you pay me? Or do you hand over the cash and hope I give you the keys?
This brings us to the doctrine of constructive conditions. Historically, the law was surprisingly rigid and, frankly, inefficient. We used to operate under the theory of independent promises.
Ah, yes.
The cow dispute.
The cow dispute. It's a classic case from 1615 where a seller sued a buyer for the price of a cow.
And the buyer's defense was pretty simple, right?
The buyer argued, you never delivered the cow, so I don't have to pay. And the court basically said, too bad.
Too bad.
The promises were viewed as independent. So the buyer had to pay for the cow he didn't get, and his only remedy was to file a separate lawsuit to get the cow.
That sounds incredibly inefficient. You would have lawsuits flying back and forth just to complete a single transaction.
It was a mess, and that is why the law shifted to dependent promises. The rule today is that courts imply concurrent conditions in bilateral contracts. To prevent injustice, we say that my duty to deliver the car and your duty to pay are locked together.
We have to perform at the same time.
We must perform simultaneously. This shift is huge. I want to anchor this in a landmark case because it really changed the game. Let's analyze Kingston v. Preston from 1773. This is the case where Lord Mansfield essentially rewrote the rules. First, what are the legally dispositive facts?
Okay, so in Kingston, we had a silk mercer, a textile merchant, who agreed to sell his business to his apprentice, the buyer. The buyer agreed to pay for the business over time, probably out of the profits. But, and this is crucial, the buyer promised to provide satisfactory security, basically collateral, before the transfer of the business.
So the merchant is handing over his life's work, and he wants to make sure he actually gets his retirement money. He wants some insurance.
Correct. The facts are that the buyer failed to provide that security. He was broke. However, relying on that old independent promises logic, he sued the merchant anyway for refusing to hand over the business.
He had some nerve.
He basically said, your promise to give me the business was absolute. My promise to give security was separate. Give me the keys and you can sue me later for the security.
Wow. Okay, so what was the core legal issue?
The issue was whether the buyer's provision of security was a condition precedent to the seller's duty to transfer the business, or if it was an independent covenant where the seller had to transfer the business regardless.
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
Lord Mansfield applied the rule of constructive conditions. The rule. It relies on determining the dependence of promises to ensure fairness. The elements are, first, look to the evident sense and meaning of the parties, their intent.
Okay.
Second, determine if the promises are dependent or independent based on the justice of the situation. And third, if they are dependent, the first party's performance is a condition precedent to the second party's duty.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the intent or meaning of the parties?
Well, the court looked at the reality of the transaction. The seller was giving up his trade, his whole livelihood, in exchange for credit. The text of the agreement and, the whole context showed that the security was the only protection the seller had.
So it was just common sense.
The evident sense was that he would never have agreed to hand over the keys without that safety net. It was implicit in the deal.
Understood. Now what about the second element, the justice of dependence?
This is where Mansfield really shifted the law. He argued it would be the greatest injustice to force the seller to hand over his entire business to a buyer who had no money and had failed to secure the debt. Justice demanded that the seller's duty depend on the buyer's performance.
Otherwise, you're just letting the guy get robbed.
Exactly. To rule otherwise would let the buyer use the law to rob the merchant.
And after analyzing all the elements, what was the court's final conclusion?
The court held that providing security was a condition precedent. Because the promises were dependent and the buyer failed to meet the condition, the seller was fully excused from performing. He didn't have to sell the business.
So Kingston teaches us that courts will read ifs into the contract to make sure things happen in a logical order. But let's look at the flip side. What if a condition isn't met, but the other party acts like it doesn't matter? This brings us to waiver.
Right. The general rule for waiver is the intentional relinquishment of a known right. But there is a crucial limitation element here.
What's that?
Waiver only applies to ancillary or minor conditions. It does not apply to material parts of the exchange.
The phrase usually used is, you cannot waive yourself into a gift.
Exactly. You can waive the requirement that I use a blue pen to sign the check. You cannot waive the requirement that I actually pay you the money unless you intend to give me the car for free. That would require new consideration.
Let's analyze Clark v. West. This is a favorite of law students everywhere because it involves a law professor, a book deal, and a whole lot of alcohol. First, what are the legally dispositive facts?
A law professor agreed to write a comprehensive book on corporations for a publisher. The contract had a really specific payment structure. The standard pay was $2 per page. However, the contract stated he would receive a bonus of $6 per page if the author totally abstained from alcohol during the writing process.
High-stakes sobriety. I mean, it wasn't just a bonus, it tripled his fee.
It did. The facts show the author did not abstain, he drank. However, the publisher knew he was drinking.
They saw him.
They saw him. Despite this, they accepted the manuscript anyway and expressly promised to pay the full $6 rate regardless. Later, they changed their mind and refused to pay the bonus, citing the breach.
And what was the core legal issue?
The issue was whether the publisher's conduct, knowing about the drinking and promising to pay anyway, constituted a valid waiver of the condition of abstinence, legally entitling the author to the higher rate.
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the rule of waiver. The elements are, first, the condition being waived must be ancillary, meaning it is not the main consideration for the contract.
Okay.
And second, the party must clearly manifest an intent to abandon the right while having full knowledge of the facts.
Thank you. Now for the court's elemental analysis. How did the court apply the first element regarding whether the condition was ancillary?
This was the crux of the argument. The publisher argued that sobriety was the consideration, that they were buying a sober book.
But the court didn't buy that.
The court disagreed. They analyzed the purpose of the contract and determined the publisher bargained for a good book on corporations, not a sober author. The sobriety clause was just a tool, an ancillary measure to ensure the work got done. Therefore, it was procedural, not material.
Understood. Now, what about the second element, the manifestation of intent?
The evidence was strong. The publisher was fully aware the author was drinking. Despite this, they accepted the pages and repeatedly promised to pay the $6 rate. This conduct was a clear, intentional election to forego the advantage of the sobriety clause.
So they couldn't have it both ways.
They couldn't play games with the condition, ignoring it when they wanted the pages, and then enforcing it when they had to pay.
And after analyzing all the elements, what was the court's final conclusion?
The court concluded the condition was validly waived. Because it was ancillary and the publisher intentionally gave it up, the author was entitled to the full $6 per page.
I love that case because it highlights that you can't be wishy-washy with conditions. If you say it doesn't matter, you can't later say it does. Now let's ramp up the stakes. What if the condition doesn't happen because one party actively stops it from happening?
This is the doctrine of interference or hindrance. The rule is simple. A party cannot benefit from the non-occurrence of a condition if they are the one who caused that non-occurrence.
You can't trip the runner and then complain he lost the race.
Exactly. You cannot tackle the quarterback and then complain he didn't throw a touchdown.
I want a visceral example to lock this in our listeners' memory.
Well, you can't get much more visceral than the murderous husband hypothetical.
Oh boy, lay it out for us.
The scenario involved a prenuptial agreement. It stated that the wife would receive $20,000 from the husband's estate only if she survived the husband. That's the condition precedent, her survival.
And the act.
The husband murdered the wife.
So technically the condition failed. She did not survive him, she died first.
Technically, yes. The husband's lawyers actually argued that. She died first, so the condition failed, so we don't owe the money.
Unbelievable.
But legally, the result is that the condition is excused. Because the husband made the condition impossible by his own criminal act, the law treats it as if the condition happened. Her estate got the money.
You cannot rely on a failure of condition that you yourself caused.
Never.
That is extreme but unforgettable. Let's look at a slightly less gruesome example. This happens in construction all the time.
Right. A homeowner was unhappy with the builder's pace. She literally blocked the builder from entering the house to finish the job. She locked him out. Then, she refused to pay him because the work wasn't done.
You didn't finish the job, so I don't have to pay.
Exactly. But the court confirmed there is an implied condition of cooperation. You cannot lock the door and then sue for non-completion. By hindering the builder, she excused the condition of completion. She had to pay the profit he would have made.
So we have waiver. I choose to ignore the condition. We have hindrance. I forced the condition to fail.
Yeah.
Now we move to the final and perhaps most complex excuse, forfeiture. This is when the court steps in and says, even though you messed up, the punishment doesn't fit the crime.
Correct. This is pure equity. The general rule is that equity abhors forfeiture. A court may excuse a condition if 3 elements are met. First, the forfeiture must be disproportionate, meaning the loss is extreme compared to the breach.
Oh, yeah.
Second, the failure to meet the condition must not be grossly negligent or willful. And third, the other party is not significantly prejudiced by the excuse.
Let's analyze JNA Realty Corp v. Cross Bay Chelsea, Inc. This is the classic case for this doctrine. First, what are the legally dispositive facts?
Okay, we have a commercial tenant, a restaurant owner. They had a lease with an incredibly valuable option to renew for 24 years. The condition was that they had to give notice in writing 6 months before the current term ended.
So a pretty simple requirement.
Very simple. The tenant had spent huge sums on renovations and building up the restaurant's goodwill, their customer base. But through simple negligence, they forgot to send the notice and sent it late. The landlord sought to evict them.
And then what was the core legal issue?
The issue was whether equity should intervene to excuse the tenant's negligent failure to satisfy the express condition of timely notice, specifically to prevent a forfeiture of their investment.
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
They applied the equitable rule against forfeiture. The testable elements are: 1, the party seeking excuse must have made valuable improvements or investments that would be lost. That's the forfeiture element.
Right.
2, the default must be due to mere negligence or an honest mistake, not bad faith. And 3, the other party, the landlord, must not have changed their position in reliance on the mistake, so there's no prejudice.
Thank you. Now for the court's elemental analysis. How did the court apply the first element regarding forfeiture?
The court looked at the money. The tenant had sunk significant capital into physical renovations, kitchens, dining rooms. More importantly, they would lose the goodwill of the location.
Oh, they're customers.
Right. If they were kicked out, they lose the value of being an established local spot. To lose all that because of a missed deadline was considered a massive, disproportionate financial loss.
Understood. Now what about the second and third elements, negligence versus prejudice?
Regarding negligence, the court found the tenant was just careless. It was an honest mistake, not a willful attempt to manipulate the landlord. And crucially, regarding the third element, the landlord hadn't leased the space to anyone else yet.
So they weren't harmed.
They hadn't relied on the silence, so excusing the delay and letting the tenant stay didn't actually harm the landlord. It just maintained the status quo.
And after analyzing all the elements, what was the court's final conclusion?
The court excused the condition. The tenant was allowed to renew the lease despite the late notice. Equity stepped in to prevent the gotcha moment.
It really shows how the law tries to balance strict rules with basic fairness. We've covered a lot of ground here. Classification, constructive conditions, waiver, hindrance, forfeiture. For the student listening who needs to apply this on an exam, let's synthesize this. Can you give us a diagnostic checklist?
Absolutely. Here is your conditions diagnostic checklist. If you see a contract problem with an if in it, run through these 5 steps.
Step 1.
Identify. Is there a condition? Look for the magic words. If, provided that, subject to, or on the condition that.
Step 2.
Classify. Is it precedent, something that must happen before the duty arises, or subsequent something that cuts off the duty? Also, ask if it is express, written down, or constructive, implied by the court for fairness.
Step 3.
Satisfaction. If the condition is about satisfaction, ask what standard applies. Is it a matter of taste like a portrait, which is subjective and requires good faith? Or is it utility like a machine, which requires an objective, reasonable person standard?
Step 4.
Compliance. Has the condition occurred? Remember, for express conditions, strict compliance is usually required. Close enough generally doesn't count unless we get to step 5.
And step 5.
Excuse. This is the if not step. If the condition failed, is there an excuse that saves the contract? Check your list. Waiver, did they voluntarily give it up? A estoppel, did they mislead the other party? Hindrance, did they block the condition? Or forfeiture, would strict enforcement be disproportionately unfair?
That is a powerful framework. Identify, classify, satisfaction, compliance, and excuse.
If you follow that path, you won't get lost in the analysis.
Thank you. Conditions really are the gatekeepers of contractual duties. They control when the machine starts and when it stops.
They do. They're the logic gates of the legal code.
Before we go, I want to leave you with a thought to mull over. We spent a lot of time discussing J&A Realty and the idea that equity abhors forfeiture. But think about what that implies. If strict compliance is the rule, but a judge can step in and say, that's not fair because you lost too much money, does a contract ever truly mean exactly what it says? Or is every if just a maybe waiting for a judge's opinion?
That is the eternal tension between certainty and justice.
And that is where we will leave it. Thanks for listening to The Deep Dive. We'll see you next time.